September 9th, 2022. Jacksonville officers were conducting a narcotics investigation when they took a man named Ronnie Reed into custody. At first, officers searched Reed and found nothing.
No, not like that, bro. Not like that, man.
That's weird, man.
Not like that.
I went to search the drawers, you started jumping up and down.
No, I told you you could take me in there.
Let's loosen up the pants here.
They already loosened, bro. The belt, I'm buckling all that shit, man.
Okay.
But then they decided to take the search further. Reed immediately became uncomfortable. He told the officers that he did not want the search to go too far. He said they could take him somewhere more private, but he did not want anything inappropriate to happen. The officers told him that nothing was going to be placed inside of him. They said they only needed to make sure he did not have anything hidden on his body. At this point, the exchange between Reed and the officers may seem almost casual. There are jokes, back-and-forth comments, and moments where the tone does not sound serious. But the situation itself was extremely serious. A man was in custody. Officers were searching him. And this was no longer just a simple pat-down. This had now entered Fourth Amendment territory. The Fourth Amendment protects people from unreasonable searches and seizures. So, from a supervisor's point of view, this is exactly the kind of moment where officers must be very careful. Even if the conversation sounds light, the legal issue is not light at all.
Lean forward.
Bro, man, come on,
See,
man.
this is, no, stop. You're going to lean forward.
Bro,
You're going to lean forward.
do this. Bro, listen, bro. You doing too much,
No, I'm not.
man. You're doing too much.
I just told you nothing was going to be put inside of you, but you got to let me look.
You can't bend me over like that, bro. I know my rights. Man.
Stop. He's clenching hard. He's got something up there.
I ain't clenching nothing.
Stop.
Put him against the car right there.
The question becomes very simple. Were the officers staying within the law, or were they crossing the line? As the search continued, Reed became more resistant. He told the officers they were doing too much. He said they could not bend him over like that, and reminded them that he knew his rights. One officer said Reed was clenching his body and suggested that he might have something hidden. But this is where the situation becomes complicated. Imagine being handcuffed on a public street while officers are trying to inspect a private part of your body. Whether Reed had something hidden or not, most people would naturally tense up in that situation. That reaction alone does not automatically prove guilt. It could mean he was hiding something, but it could also mean he was scared, embarrassed, uncomfortable, and trying to protect himself from what felt like an invasive search. That is why the key question remains. Was this reasonable? Was it reasonable to conduct this kind of search in public during a narcotics investigation? Later, on July 25, 2023, Detective Riot conducted an internal affairs interview with Detective Joel Bellegarde. The purpose of the interview was to investigate an allegation of improper action connected to the search of Ronnie Reed.
7 years.
On September 9th of last year, 2022, you were involved in a narcotics buy-bust operation. Do you recall that?
Yes.
At that time, what was your assignment?
We were assisting narcotics. We were assisting with takedowns.
Okay. And during that time, what was your, permanent assignment with JSO?
At that time, I was assigned to the Zone 1 task force.
Okay. And you said now you're a part of the community response
Yes.
unit. So during that operation, you eventually had made some contact with suspect Ronnie Reed, who was arrested under CCR 22-533445. Do you recall Mr. Reed?
Yes.
Detective Bellegarde was asked whether he understood that anything he said during the interview could be used as a basis for discipline, although it could not be used against him in a criminal proceeding. He said yes. Internal affairs investigations like this are extremely serious. Officers are used to questioning suspects or witnesses, but being questioned by another officer is a very different experience. It can be tense, uncomfortable, and high pressure. These investigations can involve something minor, like a discourtesy complaint, or something much more serious, like a possible illegal search. In this case, the allegation was serious because it involved whether the officer's actions violated policy and constitutional protections. Detective Bellegarde explained that he had been employed with the Jacksonville Sheriff's Office for about 7 years. He was asked about the narcotics operation that happened on September 9, 2022. At that time, he said he was assisting the narcotics unit with takedowns. His permanent assignment was with the Zone 1 task force. During the operation, Reed had already been arrested under a case number connected to the investigation. Bellegarde explained that he was originally involved with a different suspect. After that suspect was transported to the area where everyone was being gathered, he he first came into contact with Reed. One important detail from the interview is that Bellegarde was asked whether he knew Reed had already been searched before he got involved.
How did you become involved with Mr. Reed? I know that you originally were with a different suspect. How did you become involved with the other suspect, Mr. Reed?
Yes. After we finished where we were initially with the initial suspect we were in contact with, he was transported over to where we were going to collect everybody at the onset of the scene, and that is where I first came in contact with.
Bellegarde said he assumed Reed had probably been searched or at least patted down for weapons. However, as the investigation continued, officers realized they had not recovered certain funds that were believed to be connected to the narcotics transaction. The officers believed Reed may still have had the money hidden somewhere on him. According to Bellegarde, there was a discussion among officers. The thinking was that Reed must still have the funds or possibly narcotics hidden on his body. So Bellegarde believed Reed needed to be searched again. This is where the communication issue becomes important.
No, Reed had already been searched before you made contact with him.
I knew at that point, I shouldn't say I know, but I kind of assumed, as we all do, that he had been at least searched for or patted down for weapons. Mm-hmm. As the investigation went on, we realized we hadn't recovered those specific funds, the funds used for the transaction between the initial suspect and Mr. Reed. And so I don't believe who was involved in the conversation, but I remember it was discussed, well, Mr. Reed must have the money, it just must be hidden on him somewhere. Mm-hmm. And that's, so I just believed he hadn't been searched for the funds.
And this was a separate, because I know funds were
yes.
Retrieved from
the
initial suspect. So this was a different set of funds.
This was the funds we recovered at the first time were what one of the undercover detectives gave to him just prior to the takedown. Mm-hmm. That wasn't for the actual deal in which a different detective had observed.
There were multiple units involved. The narcotics unit was handling the investigation, while other officers were assisting with the takedown. In operations like that, communication is not always perfect. But the bigger question is not just whether there was confusion. The bigger question is whether this was a mistake of the head or a mistake of the heart. A mistake of the head means the officer made a poor decision because he misunderstood the law or policy. A mistake of the heart means the officer acted with bad intent, humiliation, or malice. Legally, the outcome may still be the same if the search was unreasonable. But when reviewing an officer's conduct, intent can matter when determining discipline and accountability. Bellegarde was asked who made the decision that Reed needed to be searched. He said he did not clearly remember who made the decision, but he understood that officers believed it needed to happen. He also said that he personally came to the conclusion that Reed should be searched because the money and narcotics had not been found.
A narcotics purchase occurred and Reed supposedly had those funds, or it was assumed that Reed had those funds. And then I guess another narcotic sale was supposed to happen, but then a takedown signal was given.
Yes.
So the original suspect still had those funds on him.
Yes, the funds from the first transaction.
Okay. A conversation was had, and the purpose of this search was to figure out where the funds were from the first transaction.
Right. Funds and or narcotics, just
right.
because Mr. Reed didn't have any narcotics on him when we came in contact with him either.
Okay.
And we, believing he completed a narcotics transaction, we believe he would have had narcotics as well.
Then he was asked how he would classify the search that was captured on body camera. At the time, Bellegarde said he did not believe it was a strip search. In his mind, a strip search meant making someone completely remove their clothing. But after reviewing department policy and state law, he said he understood that rearranging or manipulating a person's clothing could also qualify as a strip search.
He needed to be searched. You just had the understanding that
it needed to happen.
Right,
that's correct. It was, everybody kind of got together and we were like, well, we haven't found the money. He did the transaction. He must still have it. And I was like, I made the decision myself. Okay, well, let's search him then. Mm-hmm.
The search that was captured by your body camera, what would you classify that search as?
Going back to what I originally, at that time, in my mind, I believed a strip search was having someone take off their clothing, like completely removing it. Mm-hmm. I did not understand that merely manipulating or arranging, as state statute and our orders say, I was not aware that constituted a strip search. At the time, I would not have called it a strip search. Looking back, after looking at orders and state statute, I would call that a strip search.
Looking back, Bellegarde admitted that the search would be considered a strip search. That admission is important. Ignorance of the law or policy does not excuse the action. Officers are expected to know the rules that govern searches, especially when the search involves someone's private body areas. The basic standard still comes back to reasonableness. Was it reasonable to pull down or rearrange a man's clothing and inspect his private areas on a public street while looking for drugs or money? Searches usually need a legal justification. There are a few common examples. First, if a person gives clear consent, the search may be lawful. Second, if officers have probable cause and a judge signs a search warrant, the search may be lawful. Third, if there are exigent circumstances, meaning there is an urgent and immediate need to act, officers may have more room to perform a search without a warrant. But in this case, the question is whether there was any true emergency. Was there an immediate danger? Was Reed hiding a weapon that could be used right away? Was there a life-threatening situation? Or were officers simply looking for narcotics or money? That distinction matters. A true emergency might justify a highly invasive search in a public setting. For example, if someone had a device that could trigger an immediate threat, officers may need to act fast. But narcotics or money hidden on someone's body is different. That usually does not create the same level of emergency.
Clothing.
I did, yes.
But when you did that, the purpose was you said you were looking for narcotics because someone had just sold someone else narcotics.
Correct.
That got to a narcotics detective.
Correct.
And it was believed that he possibly still had narcotics concealed on him.
Correct. And he was, I know one of the other individuals interviewed mentioned though, it was pretty, and I didn't, as far as I'm aware, I don't have any contact with Mr. Reed before this incident, but it appeared that he was clenching his body. He was holding his muscles tight, and it appeared that, and not holding it in his anus, but holding it in an area where he didn't want us to get, which is why he was trying to hold his legs and buttocks tight. And that's another reason why we believed he had some sort of contraband hidden on his body.
So the issue becomes whether the officers should have waited and allowed jail staff or medical professionals to handle a more intrusive search in a controlled and private environment. Bellegarde was asked whether he rearranged Reed's clothing. He admitted that he did. He was then asked whether the purpose of rearranging Reed's clothing was to look for narcotics. He said yes. He explained that Reed had allegedly sold narcotics to someone connected to the investigation, and officers believed he might still have narcotics concealed on his body. Bellegarde also said Reed appeared to be tensing his body and holding his legs and buttocks tightly. That reaction made officers believe he may have had contraband hidden. But again, tensing up during such an invasive search does not automatically prove someone is hiding something. Most people would likely react the same way if a stranger was searching such a private area while they were handcuffed and exposed. Bellegarde did not appear to be openly deceptive in the interview. He acknowledged that after reviewing the statute and policy, he understood the search qualified as a strip search. But the bigger issue was still whether the search was reasonable under the circumstances. He was asked what the officers would have done if they had found something. Bellegarde said it would depend on what it was. If it were narcotics or money and they could see it, they might have asked Reed to remove it himself. If it were a weapon, they may have removed it for safety reasons. But Bellegarde also stated they would not remove anything that was actually inside Reed's body. That statement matters because it shows even the officer recognized there were limits. He was then asked whether Reed was visible to anyone nearby during the search. Bellegarde said he did not believe anyone could clearly see what was happening. He mentioned that there were vehicles and other objects blocking the view. He also said that he moved Reed around the corner of a vehicle to try to give him privacy. However, even if the officer believed he was trying to provide privacy, the search still happened in a public area. That is one of the central problems in this case. The interview ended with Bellegarde saying he did not have anything else to add, change, or clarify. He confirmed that everything he had said was true. The interview concluded at 1:27 p.m. After the incident, court documents showed that Ronnie Reed spent approximately 13 days in jail. He also had around 18 court appearances. Eventually, the city of Jacksonville paid $275,000 in connection with the case. The officers involved received written reprimands. Those reprimands remained in their files for a period of time and could affect things like promotions. But beyond the money and discipline, there is another question. What did Ronnie Reed experience after being searched and exposed like that in public? This is not about saying Reed was innocent of everything or that he was not involved in any criminal activity. That is not the point. The point is that nothing was found on him during that search. No charges were filed against him from that incident. He was later released from jail, and the search was ultimately found to be unreasonable and against department policy. The biggest lesson from this case is simple. Before any search, especially an invasive one, officers must ask themselves one question: is this reasonable? Because in this case, under these circumstances, the answer was no.